in the meantime, his daughter kept sending me texts of like pretty nasty texts about this whole situation, and telling me that I didn't need to be cleaning, that they were going to hire professionals to come do it, and which I ignored the text from her because the dealings are not between me and her, it is between me and John.
Hear me, yo, watching how them opera boys get sentenced. You know how the fuck's going on, man. Y'all boys tuned into that Oouchie court watch. Well, we taking it straight from the jail cell to the judge. Hear me, judge.
Good afternoon, everyone. I am on the record, and we are on the live stream. Ms. Wyeth, is Nicole with you?
I am Nicole.
Okay, I'm sorry. Then let's talk about what we're doing here. This is 241667LT. It's a landlord-tenant case for a property on Portage Avenue. The plaintiffs were John and Verna Cruz. John Cruz is here with his daughter, Lynette Page. Also watching is his other daughter, Pam Malinowski. We had a somewhat lengthy possession hearing, and the Cruzes got possession of the property. Then they sued for additional money damages, and Miss Wyeth did not appear, and a judgment entered against her in December of 2024 for $6,234 for rent and other costs. In an effort to collect on that debt, the Cruzes have been attempting to have a monthly installment payment. The defendant, I think, made payments for a while, then didn't make payments. Mr. Cruz, what's the current status? Are you getting payments?
No, are you getting any payments?
No, I have no payments.
All right. Ms. Wyeth, what's your position?
Okay, Your Honor, first I would like to bring to your attention that I did not get any paperwork to appear for court in December, because apparently the papers were sent to the 409 Portage Avenue address and not my current address, in which the court and Mr. Cruz had at the time. So,
all right, well, let's talk about that. The law requires when you move that you turn in the keys and give your forwarding address in writing within 4 days of your moving. And so the notice was sent to the address because we didn't have another address. So at this point, I think you're asking to move to set aside the default, but the default entered more than 21 days ago.
Because I was told when I called the courts, when I got notified that I had court today, I called the court and explained to them that I never received anything to come to court in
Well, let's talk about that. We don't do things by telephone call. So if you wish to file a written pleading or a letter or something explaining the circumstance, you have an opportunity to do that. The contention is that the Cruzes complied with their obligations under the law, because when you move, you're required to give your forwarding address in writing.
I did, Your Honor.
All right, well, that may be something to be further explored. You haven't made a motion to set aside the default. The default entered on December 27th. It's now March 3rd. You have 21 days. I'm sorry.
You said that the default ended on December 27th?
That's what I show, December 27th of 2024.
I didn't even get any notification of any of this until way after December. And I had a police officer.
Okay. So you don't do it by a telephone call, and you don't do it by saying, hey, but the contention is that you didn't follow the law under the Landlord-Tenant Relationship Act. I don't know whether that's true or not. The notice went to the address that the court had. We don't know whether, so the default judgment entered. you have 21 days to move to set aside the default. So I'm in the paper file. Let me look in the electronic file.
Your Honor, may I speak? May I say something?
Yes.
Okay, so when I had a police officer take my forwarding address over to John Cruz's house, so that way he had it. And the reasoning of that being is because of John's daughter and son-in-law kept bothering me, would not leave me alone. I was told not to go to their house. I was told not to step on their property. And this was even before I had even moved out. So I had the officer take the forwarding address over to John and give it to him. So they had the correct address through the whole thing.
I didn't get anything.
Yeah, what? What?
Asked George what the address was that she gave.
Well, let me take a look at this. Meg, you came in late to this, but this is default on a money damage request. There's a notice for her to appear via Zoom on 12/27/24. The notice is dated March 3rd of 2025, which is today. That doesn't make any sense.
When I had spoke to the lady at the courthouse, she had informed me that they have a new secretary or whoever is supposed to put the new addresses in the computer, that they have a new one and it was failed to go through. Like she didn't process my new address. And that's why I didn't get the notice, is what I was told.
She wasn't.
I have no problem paying John and Verma what I owe them, and it would be more than happy to pay them what I owe them, but I don't feel as if this has been done fairly.
Well, the notice, I'm having trouble making sense out of the notice was for 12/27 at 11 a.m. Supplemental complaint for money damages, notice of hearing. Notice of hearing. Notice of hearing. None of these have a date on them.
Like the last thing that I had received from the court is when I went to when we had went to the court the last time to seize the property. And then after that, I had papers handed to me, which was way after December.
I can't tell from what I'm looking at. All the notices were to 409 Portage Avenue.
And that's not the correct address.
But I can't tell when that was done. December 2nd, looks like the notices went. Directed to appear by Zoom on 12/27, December 2nd, 2024. So the Cruzes were there, both of them. Both daughters were there. They were placed under oath. I took testimony and found that the damages were $6,236. That would be rent and court costs. So I entered that judgment on 12/27. I think that may have been the last business day of last year. So then we set this hearing 433. Again, the address was 409 Portage Avenue. How did you get this notice?
Well, a processor came to my current address to give me the papers, in which I was not home at the time. So I contacted him and then met with him at Myers, and he gave me the papers there. That's how I learned about this. But
Then the subpoena went to the Cotherman Lake Road address. So that you were served with a subpoena. All right. Now, somewhere I was under the belief that you had been making some payments. Did you ever make any payment to the cruises?
No, sir. No, sir, I have not. Back when I was moving out, I had went and got a cashier's check for John. And with that being said, when we went to court, you had said that John could not receive any money or everything would go into fault on his end. So I withheld the check. So because I didn't want to give him the check because of it defaulting or whatever, I didn't really understand.
Well, at that point, I guess it could have been, but I'm trying to Mr. Cruz, did you get in writing from her what her forwarding address was?
Yes.
Did you ever inform the court of that?
Bruce knew about it, the process server, Your Honor, because on the subpoena that we had to fill out, we did put the correct Cotherman Lake Road address on it.
Yeah, but that wasn't until after the default entered on December 27th. So it appears that she had given a proper forwarding address, but you didn't tell us. So the notice for the hearing went to the 409
Portage Avenue.
Yes. Ms. Bauer, do you have a take on this?
I certainly think that satisfies the first prong of the good cause for not appearing at the hearing element for setting aside a default. I have other thoughts about the statute, but I'll spare the record. This
Right,
section.
Yeah, it isn't always clear. Let's go back to the original judgment. The defendant entered into a consent judgment agreeing to move by November 12th. No money judgment was entered at that time, and it was clear there would be a subsequent hearing. So sometime at about that point, now she didn't move, and the Cruzes had to actually move to evict her. And
Your Honor,
Sergeant Morse,
I'm sorry, go ahead.
It appears that there was actually a writ of eviction sometime after November 13th. Go ahead.
So they did not have to do the right of eviction. I was in communication with John and was communicating him with everything that was going on. And we were moving, and it was going to take a few more days. And I spoke with John and explained to him the whole situation, and he was okay with it. And when we had gotten everything moved out, I had went over and talked to John and told him I would like to clean the premises up. And so I also had did that. In the meantime, his daughter kept sending me texts of like pretty nasty texts about this whole situation, and telling me that I didn't need to be cleaning, that they were going to hire professionals to come do it, and which I ignored the text from her because the dealings are not between me and her. It is between me and John. And I have no intent to do John wrong at all whatsoever. So, John and Verma even walked over to the property when I was cleaning the property and was okay with the whole situation.
All right, we had a hearing, as I indicated, on December 27th. It does appear it was sent to your Cotherman Road address.
Correct.
They requested June, July, August, September, and October's rent, and 16 days of November's rent. That added up to $4,980. They also had gas bills from November 23rd to October of 24, minus 2 payments you've made. So the gas bills were $1,033. So we have almost $5,000 in rent, June, July, August, September, October, and half of November. A $1,033 gas bill, which takes us to just over $6,000, plus court costs of $223. That's how they came to the $6,236. So do you contend that you didn't owe June, July, August, September, and October's rent?
June, July, no, I do not owe, but the rest, yes, I do. And as far as the gas bill, they were supposed to tell me, John was supposed to let me know how much I was supposed to pay on gas. And when I made the first payment is when I was told. Like I guess it had collected that much, and I can't I'm a single parent, so I can't just hand over that type of money all at once. So I was paying on it, like as I was paying the rent.
Well, apparently you paid $100 in April and some in May. Also, I don't see any calculation in here that I considered a security deposit.
There wasn't
Yes,
one.
I paid a security deposit. Yes, there was. Yes, there was.
When we discussed it, there was no.
All right, well, stop. So anyway, there is obviously you owe a substantial amount of money. The question is how much? The default entered. You're not an attorney. You want me to set aside the default, but you didn't file anything within the 21 days to set aside the default. Ms. Bauer pointed out that there are a couple prongs of the default set aside rule. Is there a legitimate reason for not appearing for the hearing? And it appears, yes, they didn't send it to the correct address. 2, is there a defense? There's apparently a dispute as to whether there was a security deposit and a couple of the months that are at issue. It is clear that you owe money. The question, I think, at this point is exactly how much. You did not get it. Now, I put Mr. Cruz under oath, and he testified as to what's in his petition, and I accepted that as factually correct. And I made a finding based on that, but you weren't here to dispute it. And I must have asked the question about a security deposit. I almost always do. The lease says, let's see what the lease says.
Are you looking at the lease that I signed or the lease that I didn't sign, Your Honor?
probably the one you signed. Let me see if I can find it. Here it is. Security deposit. 0, it says here. So apparently I didn't consider a security deposit.
On that lease, what was the dates on that lease that you're looking at?
I'll tell you. It was filed with a complaint that you got served on you. Beginning November 2023 and ending October 31, 24.
Okay, and so in that lease, it shows that I signed that lease?
No, it shows their signature. Your name is printed on it, but there's no signature on it. So is there an earlier lease where you did pay a security deposit?
Yes, Your Honor.
Your
What's the
Honor.
date of that?
I would have to find that lease, Your Honor. I don't have that lease in front of me at the moment, but that was when I very first moved in there.
Your
When
Honor,
did you first moved in?
I think it might have been December of 2020. I could be wrong.
All right, well, so there's another factual issue. So there's a factual issue about payments for which months and a factual issue about security deposit.
Your Honor, can I mention something about that contract that she didn't sign? That one was when she decided to take over the entire house because the lower residents had moved out. So we created a new agreement at that time, and it was discussed with her. And when it was brought up about security deposit, she mentioned that there had not been a security deposit. And each time we tried to get her to.
Well, let me stop you. Let me stop you. We're not under oath. We're gonna have to have a hearing on this. The defendant was not given notice of the hearing, despite the fact that the plaintiff had the corrected address, but didn't share it with the court. And they're lay people. They're doing the best they can. Their daughters are helping, and they're not attorneys either. It's clear that something is owed in a substantial amount, but we need to pin these issues down. So at this point, this is a terrible way to do this. What I'm trying to get at is the truth. I will grant defendant's oral motion to set aside the default judgment. And I'm gonna set a damage hearing. I'll do it by Zoom. Everybody seems to be capable of dealing with that. And find out how much is owed, pin the number down. Then they're going to be able to collect on the debt. That's what this hearing was set for. It's called a discovery hearing, and they're going to place you under oath and ask about your ability to pay on this debt. Where are you working? What are your assets? What are your bank account numbers? What's your social security number? My sense of it is you don't have a lot of money, and they're going to have a hard time collecting this debt. But the least we can do is try to get the correct figure. So there's the gas bill, there's rent, and there's the security deposit. They didn't ask for any other damage other than that. You dispute 2 of the months and you contend that there's a security deposit. So if you have an earlier lease that shows a security deposit, you need to find it.
Yes,
Because
sir.
you saying there is one and them saying there isn't one. Also, you didn't sign that most recent lease, at least if there's a signed copy, I haven't seen it. So, Ms. Page, if you've got a signed copy of that last lease, I'm gonna need to see that as well. All right, I've got my customers behind me stacked up, waiting for their hearing. So I'm gonna grant your motion to set aside a default. I'm gonna reset a hearing on damages. Where we'll pin down the exact number. It's gonna be north of $4,000, probably at the low end. We'll see. If we take off 2 months and a security deposit, I don't know. Anyway, the Cruzes were under oath and testified as to the damages that I found. Nonetheless, you didn't know there was a hearing. So I'm gonna reset it for a hearing. I'm gonna block out 2 hours.
No, you don't mean it in a bad way. You don't just in talking.
All right, that's Mr. and Mrs. Cruz and Pam and Lynette. That's the best I can do at this point. We're gonna take another crack at this. I'll give you the date. We'll do it by Zoom. You've done a good job of helping. And the defendant has come in by Zoom. Her name isn't Basha, but Nicole. All right. Meg, do you wish to consult with the defendant at all, or just simply leave it as scheduled for a hearing?
I'm certainly always available to any defendant that would like to consult with us. So if Ms. Wyeth would like to speak with me, I'm open to that.
Do you wish to speak to, it might be better if you do wish to speak to them, you contact them, because she's gonna have some obligations with me here. As I said, I'm backing up. So, all right, I will give you a new date. I will use the Cotherman Lake Road address. We'll schedule a Zoom hearing regarding money damages and pin the number down. All right, you're all good to go.
Watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie court watch quick as a flash.